Right, this is LAWS12066, and this is the lecture for topic 3, which is our second instalment on the Torrens system. And in this topic, we will be considering exceptions to indefeasibility. Now, this is a critical area because the doctrine of indefeasibility, and in Queensland, as we know, that's found within the Land Title Act. That is, the concept is embedded in the legislation, not in the cognate acts of all the jurisdictions. Others, yes, but not all, but certainly in Queensland. But it would appear that the idea of indefeasibility and the extent to which it extends, as we saw in the previous lecture, not just to the registered proprietor, that is the title holder with regard to the parcel of Torrens land, but to other interests, for example, mortgages, and also to arguably the terms and conditions of those mortgages in certain situations. Right? So the reach of indefeasibility is arguably quite broad, and as we've seen, it doesn't matter whether or not the instrument which has been used to register the interest which and creates the title is void. Registration cures that almost entirely, but there are some aspects of that need to be concerned about. But the point is that it seems to be a blanket protection and radically different to the sort of quality of title that was available under real property law, under the general law, previously and prior to the introduction of the Torrens system. The important qualification to that is the fact that there are exceptions to indefeasibility. So I'm just going to start screen sharing as I have in the previous lectures. First screen that I want to screen share with you is the Moodle page. Now, the reason I'm doing that is because there's a bit of an explanation there about the exceptions and the nature of what we're doing, but just want to point out that the areas, just going to stop screen sharing that just for a moment. I've got the wrong screen, just give me a sec. Just un momento, students, un momento. Right, that looks a bit better. Just going to go back to screen sharing that. That's right. So it's a nice clean version. That's what I wanted. When I'm working on it, of course, it's got various bits and pieces there. So what I want to just point out to you is, apart from obviously the notes and lecture slides, so further resources. Now, I've given you, as well as the material in the casebook, and I'll refer to that just in a moment. Importantly, I've given you the Cassegrain and Gerard Cassegrain decision, which is a 2015 decision of the High Court. It's referred to in the casebook, but encourage you to read the joint judgment in the Cassegrain decision, and I might actually do a separate podcast on that because it's an important case and a bit challenging, but a very recent High Court decision giving us some clarity around the nature of some aspects of the exceptions to indefeasibility, in particular the fraud exception. The article by Moses and Edgeworth is also interesting in laying out the nature of the in personam exception, or the personal equity exception, both in its historical context, but also within the environment in which it needs to work today in the current period. So I encourage you to have a look at that as an additional source material. And as you can see there, there's a survey plan that I provided as well, which you can have a glance at. So I'll just stop screen sharing that. We'll go back to the slides. So that's where this is the topic we're dealing with. And what are we doing here? Just going to lift up a little bit so you can see all the resources at the bottom. So just before we go look at the objectives, just note those resources. So again, the prescribed text, but the casebook, Edgeworth, Sackville and Neave casebook, the relevant parts are in chapter 5, 5.75 to 5.161. So 5.75, you'll find that starts on page 470 and over to 161. Yep, so that's page 470 through to 533. So again, about 60 pages, like in the previous instalment. So I'm trying to chunk it up for you in a reasonable way. Just want to point out at the outset that there's a on pages 531 to 533, just going to stop screen sharing that for a sec. It's a very interesting comparative table that runs over 3 pages. It's a bit, running over 3 pages, a bit sort of logistically challenging, I suppose. But particularly given the fact that there are various ones of you that are in different jurisdictions around Australia, even though we are in the unit, of course, benchmarking against the Queensland legal framework and legislative framework, helpful for all of us just to have that comparative table there, to have a quick, almost like a ready reckoner of the key provisions. And I would really, as a bit of a tip, Michael's tips and tricks, if you like, going forward, especially for the exam, is to photocopy that. I mean, obviously you might take the casebook into the exam, it being an open book exam, but just as a quick reference, you could actually photocopy it and mark it up and highlight it and tab mark it so that you quick reference to the key sections for the purposes of the exam with regard to torrents. There are other resources that we'll indicate too, of course, going forward, but that's just important. And then the comparative aspect, for those of you in other parts of the country and other states and territories, you can actually have a look at the relevant sections that equate to those in Queensland in your jurisdiction. So it's like most things in land law, it's a 2-for-1. So I think it's quite useful. So we'll go back to the slides. And so what we're looking at here is how the exceptions work. What are the different types of exceptions? And really the truth is fall into 3 broad groups, if you like. We start with the legislative provisions and understand that, but the fraud exception, that's a very important exception, and understanding what that means in terms of the torrents legislation. There's a lot of debate in the case law and in the commentary about, well, what does torrents fraud actually mean? Does it mean fraud as we would generally understand it? Does it mean fraud understood by the common law? Does it extend to include, for example, the nature of fraud that a court of equity might recognise? We'll actually see that it's got quite a tight and narrow perspective, and one of the reasons for that, of course, is that if statutory fraud under the torrents legislation is established and proven as through the process that's necessary, it forms an exception to indefeasibility, which means that the title, the quality of the interest which is held to be indefeasible becomes defeasible. That means it's subject to other interests, or it may have other consequences, which are very significant. And that also has flow-on effects with regard to just the nature of recognising the torrent system and what it gives. But it's there, established as a statutory exception. We'll get to that momentarily. The in personam exception, and in Queensland, but not in every jurisdiction, by no means, We have a relevant provision within the Land Title Act dealing with personal equities. We then have a range of other types of exceptions that don't receive as much attention because they haven't been as much debated either in the case law or in the commentary, but just to be having awareness of them. Actually, we saw one back in LAWS12066 Foundations Property Law when we looked at adverse possession, and we noted that there is a paragraph in the relevant section of the Land Title Act that actually recognises that if a claim of adverse possession is proven with regard to Torrens title land, then it will constitute an exception. And that means that the adverse possessor can then ultimately allow, as we commented on at the time, allow their interest to mature into full Torrens title and full indefeasible title by ultimately registering, getting that recognition. We also look at just the role of the register and the registrar's powers to correct the register under the Land Title Act. Now, that will take us into an important case called Bursell and Berger Brothers, which is a case that's been taught for a long time in this area. But there's a little proviso on this now, in that 3 jurisdictions have decided to privatise/commercialise their Torrens registers. That means a private entity is now in charge of the register, but there is a regulatory oversight by the government agency. That may be the Land Titles Office, it may be Registrar General of Lands in some jurisdictions, and so on. So there's now a more complex relationship, which actually, in my view, will have implications going forward, which hasn't yet fully been worked out in terms of that, also in terms of, which we'll discuss in the last lecture on the Torrens system, the assurance principle and compensation and matters of that kind. Right, so we can see there, I'm just enlarge it a bit for you. You can see there's key terms, fraud, rights in personam, and so on. So we start by understanding that the core resources, of course, of legislation, the Land Title Act, and also the Land Title Practice Manual, very important. So I'm just going to show you those. He says, if we can find his screen, there it is. Right, so what we have is the Land Title Act, and of course, as I've mentioned previously, we look at the official version under the Queensland legislation website. And you recall from what we just looked at in terms of the slides, we're looking at section 185. So if we just scroll down, this is a convenient way of finding relevant sections in the Act. You can see there, so, again, in the Queensland Act, we find that, so Part 9 deals with registration of instruments and its effect. And when we come to subdivision B, within Division 2, consequences of registration, we find subheading of indefeasibility. You won't find that in every Torrens Act if you're not sitting in Queensland, or if you're looking at the Act of your jurisdiction, even though we're focusing on Queensland. When we go into section 185, here we go. We see that is the exceptions to 184, 184 being the section that sets up the indefeasibility idea, as specifically referred to in the Queensland Act. And then the way section 185 works is you can see that there are a number of paragraphs under subsection 1, and they are a range of statutory exceptions to indefeasibility. And you can also note that there's interesting reference there to some recent legislative developments, both in Queensland and also at a Commonwealth level, with regard to energy resources and so on. And that's the primary section that we need to be mindful of, but also be aware that, so all of 185, you can see it's rather extensive. Subsection 1A is dealing with mortgagee situation, and this is about links. You can see there the link back to 11 capital A and 11 capital B. This is in relation to the requirements of mortgagees now to be satisfied as to the identity of mortgagors that they're entering into mortgage with. And that really updates some of the case law that's in your casebook. There's reference to that in your casebook, but the previous case law predated those enactments. And they're not universal across all the jurisdictions, but we have them in Queensland, and New South Wales has also followed suit. And you can see that there's also been an amendment there in subsection 1C to take recognition of electronic conveyancing under the Electronic Conveyancing National Law Queensland. So we can't escape e-conveyancing, people. We can't escape its impact. Okay, this is not a course on conveyancing or on electronic conveyancing, but we can't escape the impact that this is having and will continue to have in this area. Indeed, as technology continues to evolve, it's going to have an even larger impact, in my view. And also, you can see, for example, down subsection 3 deals with easements and those areas. All right. So, and then if we come across to stop screen sharing that to the land title practice manual. Again, I'm just sharing these up front so that you've sort of conscious of the resources that are relevant to this topic. Now, the manual is quite long and extensive, but I really urge you to download a PDF version of that, which you can get from the Department of Natural Resources and Mines. You can see the website there, dnrme.qld.gov.au. Various aspects will be relevant as we go through. There's a section on mortgages and the National Mortgage Form. Now, you might say, oh, but why are we talking about mortgages, Michael? Because surely that relates to the topic at the end of the course, topic 10 on the law of mortgages. Yes and no. It's a good lawyer's answer, isn't it? Yes, it does relate to that topic, but the law of mortgages is about other issues in terms of the rights, the responsibilities of the parties to a mortgage, the powers that are available, particularly to the mortgagee, especially in the circumstances where there's default by a mortgagor, and what they can do, what they can't do, and what protections are available and aren't, and these sorts of things, and also the nature of the mortgage under the torrent system. But you will notice that, we'll come to the fraud exception just momentarily, but you will notice that the discussion, particularly in the area of fraud, but also to some degree in the personal equity area, personal equity exception area, is often involving a mortgage transaction, mortgage instrument. Why is that? Well, because the two most critical instruments, property law instruments, in terms of interest in land, is firstly the transfer, which gets lodged for registration, which is actually what creates the the indefeasible title by the lodgement of the transfer when you're acquiring land, purchasing land. It can be voluntarily, as we saw in the last class. It can be a voluntary transfer, but most for consideration, of course. Or the mortgage, which is involving financing with regard to the acquisition of the property. And of course, property is extremely valuable. In fact, it's more valuable. I say it's more valuable than money's worth. Why is that? Because of its capacity to accrete in value, and not just be about the actual amount of the original investment, if you like, in terms of the purchase price. And because of those financial implications, the mortgage is quite critical and often disputed over in terms of its enforcement, because it's a security interest with respect to the land, and then that the financier that's got the security interest wants to exercise that, and there's issues around validity and enforceability and so on and so forth. So you'll see that's discussed in your materials in Chapter 5 in regard to the exceptions to indefeasibility. Specifically, there's reference to the mortgage and the new verification of identity requirements, and specific reference to the Queensland provisions at paragraph 5.84, pages 476 to 477. So, and as we saw earlier, mortgages have been relevant in terms of thinking about the extent of how far indefeasibility extends as well, the mercantile credits and shell case. So in this context, part 2 is relevant, but I want to go all the way down to paragraph 60, if I can get there. Down to paragraph 60, if I got there. Nope. I want to get to paragraph 62,000. Almost there, almost there. Here we are, people, that's what I want to show you. So paragraph 60-2000, it's quite a long document, the Land Title Practice Manual. Verification of identity standard. Very important. So we find in the Land Title Practice Manual a reference to the VOI standard. Okay, you can see there a clear reference back to those sections of the Land Title Act. Don't worry about the Land Act, that's with regard to transactions involving that. We're not concerned with that, we're concerned with the LTA. 11A, 11 capital A, 11 capital B. And they are the sections that are specifically, as I just mentioned, identified for you on pages 476 to 477 of your casebook. This area, I mean, this part of the Land Title Practice Manual goes on. It looks at all of the features, the requirements that are necessary with regard to verification of identity. Now, this idea of that's been was embedded in these amendments to the Land Title Act through sections 11 capital A and capital B, they actually came in before electronic conveyancing was implemented, because it was about the concern around banking practices and around what steps were being taken by mortgagees in banking practice when creating loans to establish the true and genuine identity of the mortgagors. And under Torrens mortgage, which we'll discover toward the end of the course, it's the mortgagor, they continue to own the property, right? But if they're a fraudster or there's been fabrications in the process, in the documents, then what implications does that have when the mortgage has been registered, given the consequences of indefeasibility? So this is quite important. I encourage you to have a good look at these areas of the Land Title Practice Manual. Just come back to the slides. So we've got those foundation primary sources to consider. In terms of, now we've got these exceptions, as I mentioned. So we've got the fraud exception. Now, I wanted to sort of give you a bit of sense of how to get through this material, because, yes, I've said it's 60 pages, but look, it you know, the material is challenging, and at different points, you've got to work with it, and you've got to, you know, I dare say you'll need to read it a few times, some aspects of it. It's a bit challenging, a bit dense, is that the word I want? I don't know. You just got to work with it, folks. And so, but there's a lot of case law referred to. Not every case is a case extract in the case book. You know, they're the key cases. But again, we're looking for the, you know, the more recent law, the law that helps us to understand the position in Queensland and not all of the jurisdictions. Remember, the case book is intended and written to cover all the jurisdictions. So sometimes it'll be referring to a Victorian case or Western Australia case or, you know, Queensland case or New South Wales. Those cases aren't unhelpful, but again, we are being mindful that it is in the context of the Queensland Act. If I just pause for a moment, and I said I might do a separate podcast on the Cassegrain case because it's so important, but I just want to read you something from the joint judgment of French, Hain, Bell and Gagler in Cassegrain and Cassegrain. And they were talking about I'm not going to go into detail at the minute about the judgment, but just want to refer to, they started by considering, well, you know, this is in the area of Torrens title. How should we tackle this, right? And at paragraph 16 of the joint judgment, they have a heading just before the paragraph starts, Torrens title. That's helpful, isn't it? Very helpful. So judges do that these days under modern judicial writing. They will put headings, subheadings, just like you can in your exam or in your assignments. Right? First sentence, and they're talking about, just leading us into, when we're talking about Torrens title. This is paragraph 16. Legislation implementing the Torrens system of land title is not uniform throughout Australia. Care must always be taken, therefore, to consider and apply the particular statute which is engaged. It's salutary. Sometimes even commentators wander off into the groves of case law, believing that that's going to provide the terrain for what they need to tackle in terms of this particular area of this part of the law that they're concerned with. We can never forget that the Torrens system is underpinned and finds its resonance through the legislative enactment. It is a legislative scheme. So we must start with the legislative language and then proceed to the case law insofar as it's helpful to allow us to understand the nature of what our Act, in this case the LTA, is providing us with. So in this area of fraud, we've got a very early Privy Council decision, early 20th century, 1913 Privy Council decision of Loch Hugh and Port Sweetenham, and that was actually an appeal that went from Malaysia. But it still is quoted and stood the test of time. We've got more recent decision of Barr and Nicolay, and we also have some other cases that are focusing on different areas of fraud and carelessness. They're the provisions that I was referring to earlier with regard to the mortgagee obligations in terms of proving the identity of the mortgagor. You have a look at those. Fraud by agents and employees, and that's where the Cassegrain decision comes up. But it's of more significance. It's a bigger significance than just saying it's about agents and employees. But the Schultz case, which is referred to in the Cassegrain decision, is also important there because the Cassegrain decision basically recognised that the approach in Schultz was a correct approach. And then we move on to in personam. Barr and Nicolay comes up again when we're looking at the personal equity exception, so we'll touch back on that in a moment. But these ideas that we find in these cases, and in particular these early decisions, are helpful to give us that more clear understanding around the provisions that we're focusing on in the Queensland LTA. Let's stop screen sharing that for a moment. All right, so we're just going to have a look at some of the case law here in the LAWS12066 decision. As I said, it's an early 20th century decision that was looking at basically, you know, a situation, and you can look at the facts yourself, but where there was this a transfer of interest in land, dispute over a portion of the land, and arrangements regarding that disputed portion, and arguments or allegations that there were statements of intention which were found to be false and made fraud. And then the rubber company then took action to reclaim possession of LAWS12066 land in those circumstances. We find that, and this is noted in your notes, that the significance of the case really lies in, you know, it providing an early explanation of the standard that's involved in proving fraud under early versions of the Torrens legislation, not deriving from the Queensland context, but, you know, again, the fundamental ideas of Torrens legislation was not different, or didn't differ. And the recognition that this exception that was found within the Act was there, of course, but what was necessary to prove it, and what we were really starting to explore was this idea of fraud in terms of dishonesty, and how that needed to be established. From that case, we had again, a Privy Council decision that went on appeal from New Zealand, and that's the decision in Assets in Mirohi, which is a 1905 Privy Council decision. In fact, you know, that case predates LAWS12066. So, you know, sort of these early decisions are, you know, disputes are occurring, appeals are being made, and then at this stage, the highest court of appeal from you know, what was essentially former English colonies or British colonies was to the Privy Council in London, as we've seen even in the previous lecture. And the LAWS12066 case is important, but the assets case is important because there's a statement there by Lord Lindley which has been quoted repeatedly since, and it uses some magic words, if I can use that way of expressing it. And Lord Lindley basically, this is what he says, right? By fraud in these acts, that is the Torrens legislation, is meant actual fraud, an unfortunate expression, and one very apt to mislead, but often used, for want of a better term, to denote transactions having consequences in equity, similar to those which flow from fraud. Further, it appears to their lordships that the fraud which must be proved in order to invalidate the title of a registered proprietor for value, whether he buys from the prior registered owner or from a person claiming under a title certified, must be brought home to the person whose registered title is impeached or his agents. Must be brought home to the registered proprietor whose title is impeached or his agents. Fraud by persons from whom he claims does not affect him unless knowledge of it is brought home to him or his agents. The mere fact that he might have found out fraud if he had been more vigilant and had made further inquiries which he omitted to make does not of itself prove fraud on his part. But if it be shown that his suspicions were aroused and that he abstained from making further inquiries for fear of learning the truth, the case is very different and fraud may be ascribed to him. That idea of fear of making further inquiries has in subsequent case law in the different jurisdictions of Australia, and Victoria has got a few decisions on this, where it has developed the idea of what's referred to as willful blindness. Okay, and you'll see that in some of the case law referred to. A person who presents for registration a document which is forged has been fraudulently obtained is not guilty of fraud if he honestly believes it to be a genuine document which can be properly acted upon. So this focus on fraud as understood as actual or personal dishonesty, and this prosaic phrase, which also has stood the test of time, moral turpitude. Right? And you'll see that come up from time to time. Moral turpitude. What on earth is the judge talking about here? Moral turpitude. We use modern pragmatic language, then we need to really talk about personal or actual dishonesty. You might say, well, look, that's not the issue, Michael. That's fine. We can look at situations. You can, but it can be a bit this way or that. It can be a bit vague, a bit grey. This also takes us into the terrain of, well, does fraud extend to include, for example, what's referred to as equitable fraud? I'll just refer to something here that, and this is just an extra source that I've got at my disposal. I'm not expecting you to have this, but there was a conference in New Zealand back in, I think it was about 2002. Chief Justice Anthony Mason, who's now no longer on the court, but was formerly Chief Justice of the High Court, very prominent judge and jurist. He gave a paper at this conference, and it was the title of the paper was Indefeasibility, Logic or Legend. And it was sort of like the opening salvo in the conference the conference was brought into a book. It was really the torrent system in the 21st century. And he, Mason's a very learned chap and sort of quite across a number of areas. And he has, in this paper, he's exploring different aspects of the torrent system and thinking about it in the context of modernity and, 21st century environment at that time. And we've even further developments, of course, have occurred since then. But he has a section here on fraud, and he says this, I'll just read a short section to you. The fraud exception to the principle of indefeasibility is not defined. Well, that's true. Initially, it was narrowly described in deference to the principle of indefeasibility and the statutory notice provisions, and was confined to actual fraud, that is dishonesty of some sort, not what is called constructive or equitable fraud. He refers to the assets case in that regard. Another description was personal dishonesty or moral turpitude. Okay, and that's also in assets. It's also in Butler and Fairclough, which we've previously seen in Term 1 course. Constructive notice is not enough, nor does mere knowledge of an unregistered interest constitute dishonesty. So I'll talk more about unregistered interests in the next lecture. The fraud must be fraud in which the registered proprietor or his agents have participated. Fraud by those from whom he claims is insufficient unless he or his agents have knowledge of it or deliberately abstain from inquiry for fear of learning the truth. suspicions having been aroused. And he refers again to the assets case. He goes on and discusses various matters in the context of New Zealand, where he was giving his address. He makes reference to a Victorian decision, Victorian Supreme Court, of Macquarie Bank and 64 Throne, and you will see this discussed more. It's referred to in the discussion on the personal equity exception. But he refers to the judgment of Justice of Appeal Tadgell and takes a quote from his honest judgment and says, "It has been said that willful blindness, deliberately turning a blind eye to obvious or obviously ascertainable facts, is akin to fraud." So he's focusing on this idea of willful blindness, building on this idea of, sort of turning away from the truth, the reality of, because you don't want to see what you want to see, in a sense, right? He then goes on and says this. This is again from this paper that Mason gave. "It may well be that in some contexts, willful blindness, in itself an elusive concept, may be akin to or evidence of fraud. But in the context of Torrens' titled fraud exception, it is difficult to see how willful blindness can amount to fraud. Willful blindness may take you to the point where the purchaser has actual notice of the prior interest, but how can it take you beyond the point of notice and constitute fraud? Something more is required because," and he refers to the New Zealand provision, "makes it clear that notice is not enough." So there are some sort of further reflections on the idea of fraud. The other case that I want to focus on here is the Cassegrain decision. If I just go back and share with you, see that Cassegrain comes up in the context, as we said, of fraud by agents, but it has a wider implication. Cassegrain's case has a wider implication. Now, in the Cassegrain case, and again, you can have a look at that decision. I've got an extract for it, a PDF version of the case on the Moodle website. And that involved, transactions of company, brother and sister, directors of the company, wife, husband, shenanigans in the family, 2 transfers in regard to an agricultural holding, a dairy farm, signing documents, transfers on behalf of another, and was there the person signing able to do that as an agent of one of the other, sibling? A lot of turns and twists in the facts as arises in these situations. What makes them interesting, I have to say. But the joint judgment of French, Hain, Bell and Gagler in the High Court in 2015, this was on appeal from the New South Wales Court of Appeal. Basically, they were going through and analysing the situation, and they made those comments that I made earlier. And this is referring to the New South Wales legislation, which is not exactly the same as Queensland, but it has similarities, but it doesn't, not expressed in an identical way. So just be mindful of that. And after discussing the Torrens system and looking at the nature of agency and what amounts to agency, and also looking at the idea of joint tenancy, the court in that context where it was argued that there was fraud between joint tenants, Claude and Felicity Cassegrain, the court looked at this idea of that had been established through the case law in terms of the need for the fraud to be brought home to the person whose registered title is impeached or his agents, right? The formulation from assets. And also looked at what was necessary to establish the fraud by an agent, and the fact that they were joint tenants, does that mean that if one was fraudulent, they were necessarily both fraudulent, because joint tenancy means they're sort of one unit? We'll look more at that when we look at co-ownership a bit later in this in land law, but we saw co-ownership also in the Term 1 course, property law. And they're saying that just because they're joint tenants doesn't mean that they're automatically both fraudulent. Again, they're focusing on this idea of actual dishonesty and it needing to be brought home. And in the context of this agency situation with regard to fraud, they go back to the case of Schultz, which you saw in the slides a little bit earlier. For example, at paragraph 40, they say that the reference to fraud brought home to the person whose registered title is impeached or to his agents should be understood as it was by Street in Schultz and Corwell Properties as posing, in the case of an agent, questions about scope of authority and whether the agent's knowledge of the fraud is to be imputed to the principal. And in the end, they decided that Felicity actually hadn't been fraudulent, and that merely because Claude, a joint tenant of hers under a property that had been acquired from a company in which they were both also directors, became a joint tenant as a result of that transfer, his fraudulent activity didn't affect her or impugn her just because they were joint tenants. The fraud had to be brought home to her as well. So that focus on the needing to be brought home, even in that context of a joint tenancy, was important. And the case was very much focusing on that. And so coming back to that rationale about how the fraud exception operates. And that's really an abiding idea that travels through many of the cases in this area in the fraud exception. And, for example, you can also see the Russo and Bendigo Bank case, which is a 1993 decision of the Victorian Supreme Court. Also, that's involving a mortgage transaction and what the mortgagees did in that situation. So, to some extent, again, that's been overtaken by these amendments with regard to what mortgagees need to do in regard to the identity of mortgagors. And that's both reflected in those provisions which we've already referred to in the Land Title Act. But now it's also been further picked up in terms of processes under electronic conveyancing generally with regard to other property law instruments, transfers and so on, that needing execution. So one of the points to tease out of this discussion on fraud is that the environment within which fraud can occur today is changing with technology. That's the first point. Second point is that how it will manifest will arguably be different going forward. And then the third point is, well, if that's true, to what extent is the body of case law that we have, which is essentially focusing on paper-based transactions, to what extent does that have continuing relevance and application? It does, but we need to contextualise it within the paper-based environment within which we're operating today. And we have other issues on the horizon in terms of fraud. We have electronic fraud, we have email scamming, We have something that's, you may or may not be acquainted with, referred to as deep faking, which is about audio and images being fabricated in the online world, so that, for example, here we are, I'm doing a recording. How do you know it's me, Michael? How do you know? How do you really know? What is the verification of my identity? And this is the whole issue, but going forward, video conferencing will invariably be used in situations where it's not possible for people to physically meet. Well, does the current law and regulation deal with that or not? So particularly with the area of fraud, we're not going to do away with fraud, we're not going to do away with dishonesty and that sort of human behaviour. We have to, though, ask, how does it become relevant today in the context of the technological environment within which we're operating, within the technological context of property law transactions and electronic instruments, under electronic conveyancing protocols, and so on. So that's the situation that needs to be thought of in terms of looking at this material and discussion around fraud in the casebook, and thinking about those wider array of materials that I've drawn your attention to in terms of its relevance here. Look, I think I will finish this recording there, because that's a fair bit in one recording, and then I'm going to do another recording on the in personam exception, or the personal equity exception, and then we'll finish off with the other exceptions and the last section on the register. So we'll just break this topic up because it's a little bit in depth, and we'll stop there. So see you in the second instalment for topic 3 on exceptions to indefeasibility. Bye for now.